Hey guys, we're in chapter 5 of criminal evidence. It's titled Direct and Circumstantial Evidence. We've discussed both of these in previous chapters, so I should tell you how important they are because they've got an entire chapter named for them. After this chapter, I want you to be able to define both circumstantial and uh, direct evidence. I also want you to understand how a jury determines the weight to be given to the testimony of a witness. And we'll also discuss the weight of evidence also and how it's determined. Um, want you to be able to identify situations in which the defendant's knowledge or skills can be used as circumstantial evidence of guilt. And lastly, I want you to know when you can use prior acts of a defendant as evidence, when you can use prior acts of a defendant as evidence. We hear a lot of times you can't use things that they've done in the past because it's prejudicial and you'll influence a jury. In some cases, you can. All right, let's talk about direct evidence real quick. What is direct evidence? Direct evidence is based on personal knowledge or observation of the person testifying. No inference or presumption is needed. If the testimony is testimony believed by the jury, the fact that it relates to what is testified to is conclusively established. So you don't have to infer anything. If someone's saying something, or or the testimony, or the fact, or the way, or the evidence is put in front of you, tells you that this act did happen. If you believe it, if you believe that piece of evidence, then it's direct evidence. Now, circumstantial evidence is a little different. Circumstantial evidence indirectly proves a fact. It requires the trier of fact to use at least one inference or presumption in order to conclude that the fact exists. And we remember what trier of fact is. So, in a bench trial, the judge is the trier of fact. In a jury trial, the jury is the trier of fact. So, what the trier of fact means, and we've discussed this in previous chapters, is that you're the one looking at it. You're the one telling if this evidence is weighted and how much of it you believe, if you believe it at all or you don't believe it. So that's the trier of fact. So in a jury trial, again, the jury is the trier of fact. Let's talk a little about the weight of evidence. We haven't talked much about weight of evidence because it's so it's out there and it's a little inconclusive on how you weigh out the evidence that's presented. But really, in a jury, you're looking at how relevant or reliable a piece of evidence is. Some things a jury will look at, and there are things that's a little arguable, like this first one that we talk about is when someone's testifying, whether a witness looks at a prosecutor or the jury. Now, eye contact is big when you're in a jury trial or even a bench trial. But I know people now that don't look at me when I'm talking to them. They're honest people, so I think that can be arguable. But still, you give that perception to the jury or the judge if you're not wanting to make eye contact, that you're not telling the truth, or there's some lies or partial lies that's being told in your statement or your testimony. So if there are any evasive answers given, or a refusal to pinpoint down details, always points toward a witness being I shouldn't say uncredible at all, but losing some credibility if any evasive answers are given, or again, willing to pinpoint down details. If a witness cooperates with one side and not the other, so for example, if you've got a witness up there that's really comfortable answering all questions from the defense attorney, but when the prosecutor gets up there, they get defensive and they don't want to. Then they don't want to pinpoint down things or give good answers. Then the jury or the judge looks at it and says that they're biased for one side and not the other. If a different story, like during a police investigation, if a police takes a statement from someone and then they get on the stand and they testify in a different way, then that makes you uncredible. Also, um, a previous conviction of perjury. Now that you can use to almost impeach the testimony or make you understand that that person didn't may not be reliable on the stand. So if you've got a previous conviction of perjury, you can use that against someone, or a previous conviction for any crime that involves truthfulness. If you can show that that person may not be honest and has done the same thing before, you can see where that can be used. All right. Uh, we can't discuss everything that's going on in this chapter, but I do want to talk about a couple of things that I want you to take away from the chapter. There are several things that from each chapter that I want you to know and I want you to take with you after you leave this class. And we've talked about that before in classes like this, or any class that you're in. You're going to get a lot of stuff thrown at you, and the stuff that I really push on you, those are the things that I want you to understand and I want you to take with you after this class is over with. So let's talk about means, or means to commit a crime. You hear that all the time. Someone had the means to commit a crime. If you watch any television court shows, you'll hear this: the defendant had the means to commit the crime. What are they talking about? I'll give you a couple of examples. So if a person works at a company that manufactures explosives, and that person is a suspect in a terroristic crime involving a bombing, that person had the means to commit that crime. If a person owns a rare gun and that same make and model of that rare gun is used to commit the crime that's in question, that person had the means to commit that crime. So that's some circumstantial evidence that's thrown out there. Doesn't mean they did it, does it? But it means that they certainly had the means to do it. Next, let's talk about motive. If a husband is involved in an affair and wants a divorce, but the divorce was never finalized because the couple could not agree on a property settlement, then the wife was found dead. Now that's motive, right? So the husband definitely had motive for his wife to be caught murdered or have murdered. Now, there's one thing I wanted to touch on that I think we missed about I want to give you an example before we finish this chapter or this lecture. When we talk about direct evidence and circumstantial evidence, I like to give an example that really helped me when I was doing my undergraduate work. If you see a person running, or you have a witness that testifies they saw a person running from a murder scene with a gun in their hand, is that direct evidence, or is that circumstantial evidence? That's going to be circumstantial evidence, right? Because you can't prove without a doubt that that person shot someone, but it certainly infers. You can infer that that person may have been, they may have shot and murdered the victim. Now, let's back up. Let's do the same murder scene. Now, this person walks in the door and they see this guy pull the trigger and shoot the victim. The victim falls over dead. Now, that testimony is direct evidence, because that if you believe that testimony, that tells you that that person committed the crime. So that's the difference: an inference and conclusive evidence if you believe it. Okay, I think that's a good start. Let me know if you need anything. You guys have a great week, and don't hesitate to call me. Thanks.